Well, good afternoon, everyone, and welcome to the Hersch Lauterpacht Memorial Lectures 2026. The lectures are one of the highlights of the Centre's academic year. They are delivered annually by a person of eminence in the field of international law to commemorate the unique contribution to the development of international law of Sir Hersch Lauterpacht. I'm delighted that Professor Dapo Akande accepted our invitation to deliver this year's lecture. Professor Akande is a Chichele Professor of Public International Law at the University of Oxford, Fellow of All Souls College, and co-director of the Oxford Institute for Ethics, Law and Conflict. He is a barrister at Essex Court Chambers and has appeared before the ICJ, ITLOS, European Court of Human Rights, the African Court of Human and People's Rights, amongst others. Dapo is also a member of the International Law Commission and the UK candidate for election as a judge to the International Court of Justice. His work will be well known to all of you, from his early writings on ICJ and the Security Council, on the jurisdiction of the International Criminal Court, through to his influential work on classification of armed conflict, the Oxford Guidance on the Law Relating to Humanitarian Relief Operations, and his convenership of the Oxford Process on the international law protections in cyberspace. Professor Akande is also an expert on immunities, and it is this topic which forms the subject of his lectures this week. In keeping with the format of the lectures, we will save our questions to the end, that is to say, until the fourth session on Wednesday. So, Dapo, we are delighted to welcome you. What is yours?
Very much, Sandy. Thank you for the invitation, and thank you to all of you who are here for this lecture. There are two things that I agonized about in relation to the lectures. One I agonized about for a long time, and the other I agonized about just in the last couple of days. So the one that I agonized about for a long time is the selection of the topic, and I will come back to that. The one that I've agonized about over the last couple of days is the decision as to whether to wear a tie or not to wear a tie. Now we're back and forth in but Andy's just leaving the room. He's crucial to the story. And I look across the room, and that Sandy's out. I am the only man here without a tie. Even Sir Frank Berman, who I can normally rely on in this regard, is without a tie. So I was going to express a special gratitude to Sandy for joining me in putting on a tie today. But it's really a pleasure to be here back at the Lauterpacht Center, and of course an honor to be invited to give this year's Hersch Lauterpacht Memorial Lectures. Previous lecturers, of course, have been illustrious and eminent scholars and practitioners of international law. But it's a particular pleasure to be associated with Sir Hersch Lauterpacht for many reasons, but also because of the topic of the lecture. He wrote on everything, yes, in international law, but he made a particular contribution to the law of state immunity. Many of you will recall his article in the British Book of International Law, which was quite influential in the development towards the restrictive immunity doctrine. And of course, his contribution to international criminal law and to the Nuremberg Tribunal is very well known. One of the reasons that it's particularly pleasing for me to be back in Cambridge is because of the time that I spent here in the late 1990s. And for one of those years, I worked as an assistant to Sir Hersch Lauterpacht. I remember going to his home just a couple of doors down, and having delivered a piece of work to him earlier on, I would go into his study and he would say, "Sit down," and then he would always go and sharpen a couple of pencils, which was always the most intimidating aspect of that encounter. And then, of course, he would give very generous comments. Now, my topic over the next 3 days is the immunity of state officials and prosecutions for international crimes. And what I want to do is to examine whether state officials are entitled to immunity when it is sought to prosecute them for international crimes in the domestic courts of other countries, and also when they are wanted for prosecution by international criminal tribunals. Now, I'd like to set the scene today by offering a general overview of immunity of state officials from foreign criminal jurisdiction. And in particular, what I want to do in today's lecture is to examine the types of immunities that international law accords to state officials, to look at the reasons or the basis for these immunities, and to consider whether there are any limitations to those immunities outside of the context of prosecutions for international crimes. Tomorrow, I will focus on prosecutions for international crimes in domestic courts. So turn to whether state officials may be prosecuted for such crimes in the domestic courts of foreign states. And of course, the key question there is whether international law has developed any exceptions to the immunities that state officials ordinarily have from the criminal jurisdiction of foreign states. And then in the third lecture on Wednesday, I would like to turn to whether immunity of state officials is of any relevance when international criminal tribunals seek to prosecute serving or former state officials. Now, the focus of my lectures is the immunity of state officials, and I've underlined that in my text, from foreign criminal, and I've underlined criminal jurisdiction. Of course, a related issue, but one that I will not be discussing, except in passing, is the question of whether a state or the officials of the state are immune from civil suit relating to conduct which would amount to human rights violations or conduct that would amount to violations of international criminal law. Now, of course, there's an overlap between those issues and the topic of my lectures, but considerations relating to the immunity of the state as such and relating to civil jurisdiction are not exactly the same as those relating to immunity from criminal prosecutions. So let me go back to the first issue that I said I was agonizing about. And Sandy, this is just for your benefit. I said I was agonizing about two things: the choice of topics and the decisions were a tie. And I'm grateful to you for being the only other person I can see in the room who's Mark said, excellent. Grateful to you for also joining me. But when I was thinking about the choice of topic for these lectures, I'd say I was initially reluctant to select this topic, immunity and international crimes, in part because I have already written a bit on this topic, and I wasn't sure that there was anything new to say. However, for good or for ill, the relevance of the topic has not diminished, and there continues to be important developments that deserve reflection and perhaps reconsideration as to where the law currently stands and where it might be going. And when I had written on this topic or aspects of this topic in the past, I had dealt with these things as separate issues. And I'm grateful for the opportunity to be able to put together all of these issues in the course of one set of lectures. Just 3 weeks ago, on the 15th of May, the International Law Commission adopted on second reading a set of draft articles on the immunity of state officials from foreign criminal jurisdiction. Now, of the topics on the ILC's current program of work, this is the topic that has been under consideration for the longest period of time, having been placed on the agenda of the Commission in 2007. The Commission hopes to finish work on the topic next month in July by adopting commentaries for the draft articles just adopted. It's probably fair to say that this is also the topic that has been the most controversial one on the Commission's agenda in recent decades. As I'm sure all of you know, it's been the practice of the Commission for the last few decades to adopt texts and make decisions by consensus only. However, the Commission has resorted to a vote, not once, but twice, on the topic of immunity of state officials. The Commission resorted to a vote in adopting the text on exception to immunity for international crimes when the topic was under consideration at first reading. And the Commission again resorted to a vote just last month when it adopted that provision on the second reading. And those are the only two times that the Commission has voted in several decades. On the same day, 15th of May, that the ILC adopted the draft articles on immunity of state officials, on that day, 36 states and the European Union adopted the enlarged partial agreement of the Council of Europe on the Special Tribunal for the crime of aggression against Ukraine. It was done at a ministerial meeting in the Republic of Moldova. The Special Tribunal is actually not established by that enlarged partial agreement. It's established by a bilateral treaty, a bilateral agreement between Ukraine and the Council of Europe. Now, needless to say, in the negotiations regarding the establishment of the tribunal, one of the most difficult issues was the question of the immunity of Russian leaders, including the Russian president, and senior state officials from criminal jurisdiction. The third relevant development with regard to this topic relates to the work of the International Criminal Court. As we're all aware, the ICC has issued arrest warrants for 4 serving heads of states or governments. The arrest warrant in relation to President Vladimir Putin is well known, Prime Minister of Israel as well, but also the serving President of Myanmar has an ICC arrest warrant against him, as is the case also for the supreme leader of the Taliban in Afghanistan. And other than Afghanistan, none of those states for whom those individuals are were parties to the statute of the ICC at the time when those arrest warrants were issued. So that's a third development that made me think again about this topic. Also relevant to the topic are recent developments in national courts. Prosecutions and initiation of prosecutions of serving and former state officials, including heads of state and heads of government, in the domestic courts of other states. There's a recent decision of the French courts regarding former Syrian President Bashar al-Assad. And then, of course, this year, we have the ongoing prosecution, as we speak, in New York of the Venezuelan leader / former leader Nicolas Maduro. And then just last month, and there was something about those days around the 15th of May. So the 15th of May was Friday. That was the day of the ILC decision, the day of the adoption of the agreement of the On the Monday, the 18th of May, the US Justice Department issued indictments relating to the former Cuban president, Raul Castro. All of this, of course, raising questions relating to immunities of, in this particular case, a former head of state. Now, before I talk about the immunity of state officials, let me say one or two about state immunity more generally. So under international law, of course, a state is immune from the jurisdiction of other states in certain circumstances. And as that rule has developed, the immunity of the state is no longer regarded as absolute, but applies in cases which relate to sovereign acts. And what this means is that a state may not be sued in the courts of another state in relation to acts which are done in the exercise of sovereign authority, what is often known as acta jure imperii. Now, the rationale for state immunity in international law is based on considerations of sovereign equality. So state immunity is often justified by reference to the Latin maxim, par in parem non habet imperium, the idea that one equal cannot exercise authority over another equal. So the states are, as a matter of international law, equal. One state may not ordinarily exercise jurisdiction over another state. And that rationale for state immunity was confirmed by the ICJ in the jurisdiction of immunities case. So the jurisdiction immunities case between Germany and Italy, essentially underpinning the immunity of the state, not just in considerations of comity, but in the rule of international law predicated on sovereign equality. Now, as far as individuals are concerned, it's important to recall that we have a general regime relating to the immunity of state officials from foreign criminal jurisdiction, but international law also has special regimes or special rules relating to certain categories of officials. And it's the general regime that I want to, so not the special rule. But it's important to recall that those special rules may go further in some cases, and in some cases will be different in important respects from the general regime dealing with the immunity of state officials. Of course, we have established regimes of immunity for diplomats and consular officials, which are codified in the Vienna Convention on Diplomatic Relations and the Vienna Convention on Consular Relations. There's also a UN Convention on Special Missions, which establishes immunity for members of the special mission, but that's not as widely ratified as the two Vienna Conventions. Now, those three conventions, the two Vienna Conventions and the UN Convention, they're the product of the work of the ILC from the 50s and 60s. And the ILC's present topic on immunity of state officials in criminal jurisdiction is, in a way, the Commission returning to the topic to consider general rules having dealt with particular categories of officials. And of course, in addition to these categories that I've just talked about, representatives of states to international organizations may also benefit from immunity when this is provided for in a relevant treaty. And a good example is the UN General Convention on Privilege, or differently, the General Convention on Privileges and Immunities of the UN. Now, in its current work, the ILC in draft Article 1.2 that you see on the screen, the ILC makes clear that the draft articles that are being developed are without prejudice to special rules of international law regarding immunity from criminal jurisdiction enjoyed by persons in particular categories. One of the questions that may arise with regard to draft Article 2 is whether the list that you see there, so diplomat and persons connected with diplomatic missions, consular posts, special missions, international organizations and armed forces, whether that list is exhaustive, or whether there might be other special rules that are not included in draft Article 1.2 explicitly. And one of the reasons why this question as to whether or not this list is exhaustive, one of the reasons why that question is important, is because of the relationship between the regime of immunity, this general regime of immunity, and the regime that we have in IHL, International Humanitarian Law, of what is sometimes called combatant immunity, or what's sometimes called the belligerent's privilege. And I'll come back to it. But the important questions as to whether that is actually a regime immunity, which, if you like, interacts actually with these general rules, or whether these general rules cover the field. And as far as the ILC articles are concerned, if accommodation is to be made for the regime of combatant immunity, I think it will have to come under Article 1.2. And now you might say, well, but Article 1.2 has something there that speaks about persons connected with the armed forces of a state. Now, in my view, and I'll come back to this tomorrow, that actually may be sufficient to cover the regime of belligerent immunity. But I should note that many, perhaps even most members of the Commission, thought of this reference to members of the armed forces as a reference just to visiting armed forces. And so this wasn't really what the ILC had in mind, or at least, put it differently, what some members, most members of the ILC had in mind when drafting this provision. But I'll come back to that question and as to why that question might be important. Okay, so let's talk about why might international law accord immunity to states and state officials? What's the rationale for this? Now, the idea of immunity might be associated with impunity. So a suggestion that an actor is above the law, that the actor has license to violate the law without the possibility of accountability for such violations. Immunity might even be regarded as inconsistent with the idea of the rule of law, if it is regarded as giving, if you like, a pass or an exemption from complying with the law. Now, in relation to states, as I mentioned earlier, immunity is derived from notions of sovereign equality. If one state could subject another state to its domestic law and then allow for that foreign state to be held accountable by its domestic courts for acts done in the exercise of sovereign authority, the concept of sovereign equality would be put at risk. With regard to individuals, but I think this is also true with regard to states, it's important to recognize that the concept of immunity is not to be equated with exempting a person from responsibility as a matter of law. But in practice, it may well do so, and often does. Now, in the arrest warrant case, the ICJ emphasized this point, that immunity does not exclude responsibility as a matter of law. So the court emphasizes, however, that the immunity from jurisdiction enjoyed by incumbent ministers for foreign affairs does not mean that they enjoy impunity in respect of any crimes they may have committed, irrespective of their gravity. Court goes on to say immunity from criminal jurisdiction immunity from criminal jurisdiction and individual criminal responsibility are quite separate concepts. While jurisdictional immunity is procedural in nature, criminal responsibility is a question of substantive law. Jurisdictional immunity may well bar prosecution for a certain period or for certain offenses. It cannot exonerate the person to whom it applies from all criminal responsibility. So the court's point that immunity from foreign criminal jurisdiction is procedural is to say that immunity relates merely to barring certain procedural processes. It does not address the substantive question as to whether or not a person has violated the law. So immunity essentially says, in the criminal context, essentially says that a person cannot be prosecuted before this court at this time. It does not, at least as a matter of law, exclude the possibility that a person may be prosecuted by another court or can be prosecuted at a later time. Now, the court went on to say in the very next paragraph after this one that an incumbent or former minister for foreign affairs might be prosecuted firstly in their own domestic courts, secondly in a foreign domestic court if immunity is waived, thirdly with respect to private acts after they seize office, and fourthly, the court said they may be subject to criminal proceedings before certain international criminal courts where they have jurisdiction. And I'll return to that fourth point that the court makes in the third lecture. Now, of course, all of this is true as a matter of law, but it is also the case that for certain individuals, there continues to be impunity for violations of international law. So the prospects of prosecution before their own domestic courts will, for certain state officials, and in many cases for state leaders, only arise where they are out of power or they're falling out of favor. Having said that, though, there have actually been an impressive number of prosecutions of former heads of states before their own domestic courts, for acts which may broadly characterized as human violation. This book published, I think now 15 years ago, actually, 10, 15 years ago, at Cambridge University Press on prosecutions of heads of states. And even then, there was already quite a lengthy list of former heads of states that have been prosecuted largely in their own courts. Now, if one thinks of the reasons for immunity of individuals more broadly, you step out of the scenario dealing with international crime for a moment and just think more generally about why international law might bar states from prosecuting officials of other states. An important reason is that it protects states from interference by foreign states. If states are immune, that immunity would be undermined if state officials were not immune. States, of course, are, if you like, corporate entities. States can only act through individuals. So if the individuals who are the officials of the state are not immune from the criminal jurisdiction of foreign states, then that would in effect defeat the immunity of the state, as one state could essentially compel foreign officials to do or not to do certain things through their own domestic law. Now, in terms of the rationale for specific types of immunity that international law affords to state officials, I want to deal with those specific types. So let me turn to the types of immunity that international law accords to state officials. And recall that I'm speaking about the general regime of state immunity and not the special rules. However, this categorization actually also works for most of the special rules. So under international law, there are two broad categories of immunity that state officials might possess. So there are immunities ratione personae, or if you like, status-based immunities, so immunities that attach to a particular office or a particular status. And then there are immunities ratione materiae, so immunities that attach not to the office or the status, but rather that attach to the acts of the state official or the acts of the state agent. With regard to immunity ratione personae, that category of immunity attaches, as I say, to a particular official by virtue of the status that they hold or the office that they currently occupy. And this type of immunity applies under international law to a limited group of state officials. It's generally accepted that it applies to the head of state, heads of government, and in the arrest warrant case, the International Court of Justice held that this immunity applies also to foreign ministers. Now, this type of immunity is said to be absolute in criminal cases. So it said that there are no exceptions in relation to these officials while they are in office. And it applies for so long as the serving head of state, head of government, or foreign minister is in office. Throughout that period, the immunity is, if you like, complete, so that even if it's alleged that they've committed crimes, they remain immune. And I'll come back to this tomorrow. Furthermore, this type of immunity applies not just with regard to official acts, but also in relation to private conduct. And it applies not just in relation to acts carried out while in office, but also in relation to acts done before the person took up office. But when that person leaves, they are no longer entitled to this type of immunity. It was this sort of immunity that arose in the arrest warrant case between the Democratic Republic of Congo and Belgium before the ICJ. And in that case, the ICJ held that this immunity applies even when the person who is entitled to it is abroad on private visit. In other words, even when they're not traveling on official business, they remain entitled to this immunity. Now, as I said, in that case, in the arrest warrant case, the question that arose was whether or not this immunity applies when the person is sought for prosecution for international crimes. And the court said that it had been able to deduce that there exists under customary international law any form of exception to the rule according immunity from criminal jurisdiction and inviolability to incumbent ministers for foreign affairs where they are suspected of having committed war crimes or crimes against humanity. Now, of course, the existence of this immunity is well established in a number of national court decisions. And there are a number there that I have referred to that speak about the immunity of a serving head of state, including a more recent case by the French Court de Cassation. One of the questions that has arisen in relation to immunity rationale is the question of who may benefit from this kind of immunity. In the arrest warrant case, as I said, the ICJ held that the foreign minister was also entitled to this form of immunity, even though actually the court itself in that case, I don't think the court actually pointed to any instance of state practice, but the court that there was an immunity for the Minister of Foreign Affairs in that case. And the question of whether or not this immunity applies just to the so-called troika, so the head of state, the government, and the foreign minister, was controversial before the ICJ decision and has remained controversial thereafter, but in different ways. So in the arrest warrant case, the controversy was whether the immunity extended as far as the troika. In other words, whether it was extended beyond the head of state and the head of government. And since the arrest warrant case, the controversy has been whether or not this immunity extends beyond the troika. So whether there are other senior state officials that are entitled to this immunity. And when the ILC was considering the draft articles on immunity, that controversy remained. And there was division initially within the commission as to whether or not the immunity should extend beyond the troika, but the ILC was of the view that immunity rationale extends only to the troika. States in their response to the ILC and in their comment on the ILC work were also, I'm going to say similarly divided, but maybe that's not quite the right way to put it. Some states also took the view this immunity extended beyond the troika, though most states accepted that it just the troika. Now, this question as to whether or not the immunity applies to a broad group of state officials is one that has also arisen before domestic court. For example, serving minister for defense will be entitled to this troika, or other state officials. And the conclusion that one comes from this question depends on the rationale that one conceives of this immunity as relating to. The ICJ justified this type of immunity on the basis that it is necessary for such officials who fall within this category, to be able to engage in international relations. And in fact, in the ICJ's arrest warrant decision, the court talked about this immunity for officials such as the Minister for Foreign Affairs. And some have taken the view that the such as means that there are others beyond the Minister for Foreign Affairs. So the court justified the immunity on the basis of the necessity for such officials to be able to engage in international relations, the need to be able to travel, and that arrest by other states of these officials would unduly hamper the conduct of international relations. Come back to this slide, but let me skip to it. Now, in the joint separate opinion of Judges Higgins, Koyman, and Bergenthal, you can see this clearly expressed. So they say immunities are granted to high state officials to guarantee the proper function of mutual interstate relations which is of paramount importance for a well-ordered and harmonious international system. Now, one would argue that in the present state of international relations, many officials engage in the conduct of international relations. It's not just the Minister for Foreign Affairs. And if this is the rationale for immunity ratione personae, then these other officials should also be entitled to immunity. And as I said, some domestic courts have extended this type of immunity, for example, to ministers of defense, on the grounds that they also have international responsibility and that they also need to be able to. But in the view of the ICJ, the three officials in the Troika are different. So the ICJ took the view that as a matter of international law, the heads of state, heads of government, and foreign ministers have a special status. That it is these three officials who, for example, are entitled to sign treaties on behalf of the state without the requirement for full powers, and that these officials have a plenary competence for the conduct of foreign affairs that goes beyond that of other officials. Now, whether that is a convincing basis for distinguishing between these officials and others, I think is, at least in my view, is open to some doubt. That if it's just about the ability to conduct international relations, it seems difficult to say that it's just these three officials that are in position. However, there's arguably another basis upon which one can argue that international law confers immunity on officials within this category. And it's one that I have described as symbolic sovereignty. So the idea that, at least as far as the head of state is concerned and the head of government, that these are the officials that embody the sovereignty of the state, in the sense that if one state was able to arrest and subject to criminal prosecution these officials, the head of state and the head of government, then in effect, a state would be able to change the government of another state. So the head of state and the head of government, if they are arrested or if their inviolability is breached by one state, then you have the possibility to be able to, in effect, entirely change the government of another state. And in a sense, we've seen something like that this year. In January of this year, we saw one state arrest the leader of another state with a change in direction, shall we put it that way, of the government of another state. But of course, if that's the basis for the immunity ratione personae, then it's not entirely clear how the foreign minister fits into that category. So the head of state and the head of government would fit in fairly comfortably, but the foreign minister wouldn't fit in. But needless to say, the reaction to the arrest warrant case is such that I think it's now very difficult, if not impossible, to say that immunity ratione personae does not extend to the Minister for Foreign Affairs. No state dissented from the ICJ's decision. And similarly, in the consideration of the ICC's one, no state has also taken that the Minister for Foreign Affairs is not entitled to immunity ratione personae. So even if there was not a lot of state practice before the arrest warrant case, there certainly is such practice, now at least verbal practice. But it's having said that immunity ratione personae extends to the Troika and not beyond the Troika, it's important to remember that other officials might have a form of immunity from criminal prosecution of other states in cases where they are engaged in specific acts of international relations. So now I turn to some of the special rules that I was referring to earlier on. So the ILC's draft articles, the text that I showed you earlier, draft article 1.2, specifically mentions persons connected with special missions. And there's a category of immunity in international law relating to special missions. Now, the UN Convention on Special Missions is no widely ratified as the Vienna Convention on Diplomatic Relations and the Vienna Convention on Consular Relations, but it's still generally accepted that under customary international law, officials who are abroad on special mission are entitled to immunity, and also that they are inviolable, in the sense that they may not be arrested nor detained. The difficulty is to figure out what constitutes a special mission under international law. The Convention on Special Missions does not seek to define with any degree of specificity what constitutes a special mission, and this issue has arisen in a number of cases. Now, in this country, in the UK, this question arose in the Freedom and Justice case before the Court of Appeal. The Court of Appeal accepted that under customary international law, state officials engaged in a special mission immunity, but then sought to define what a special mission. In the view of the Court of Appeal, an official will only be regarded as abroad on a special mission where states consent. So in that sense, the invitation and the acceptance of the special mission justifies the limited immunity for the duration of that visit. So there has to be an acceptance by both the sending state and crucially also the receiving state, not just of the presence of the person on the territory, but also that they are engaged in the mission concerned. And where that is the case, the Court of Appeal recognized the immunity of the members of that special mission will be absolute. So it applies even in relation to allegation of private conduct, and would apply even in relation to allegations of crimes under international law. And in a way, this conclusion relating to special missions immunity should diffuse somewhat the debate around whether immunity ratione personae extends beyond the Troika. So those that are outside the Troika may in certain cases be entitled to immunity, but of course that will only be the case where they are abroad on a special mission. So it wouldn't extend to cases where they are on holiday or on a private visit. And that would be the essential difference between those two cases. Okay, let me turn to immunity ratione materiae. So here we're speaking about immunity that attaches to the official acts of a state agent or the official acts of a state official. Now, in some senses, this immunity is broader than immunity ratione personae, and in another sense, it is narrower. So broader in two respects. First of all, it applies to all state officials, and even to those who are not formally state officials, but simply agents of the state or acting on behalf of the state. Second, it applies not just to serving officials, but also to former officials. So these are the differences between ratione materiae immunity and ratione personae. Because the immunity attaches to the act rather than to the office. It's narrower than immunity ratione personae in the sense that it applies only to acts done in the exercise of the official capacity. So it does not apply to private acts. And so it does not apply to things that were done before the person was an official or before the person began to act in an official capacity. What is the justification for this type of immunity? And it goes back to what I said earlier on. In my view, there are two purposes for this immunity. The first, I would actually argue, is substantive. So in this regard, I would differ somewhat from the position of the ICJ in the arrest warrant case when it said in that case that the immunity, well, when it said that immunity is procedural. Actually, the ICJ was speaking of the immunity of the Minister of Foreign Affairs and speaking of immunity ratione personae, which in my view is purely procedural. But immunity ratione materiae, in my view, actually has some substantive law underpinnings, in the sense that it's a procedural device, but a procedural device for achieving a substantive point. The substantive point being that individuals are not to be held responsible for acts which are really those of the state. So again, thinking more broadly about immunity, so not international crimes now, but just generally, why does international law prevent one state from subjecting criminal prosecution of the officials of another state? Because in general, the officials of state, at least when they're acting in their official capacity, is attributable to the state. And the individual who is performing that is not to be held responsible. Personally, in general, at least I think this is the point of the international law rule. So if you go to the local council to apply for a building permit, have a house extension or something like that, and the official denies you the building permit, the question that then arises is who is responsible? Is it the state, or can you sue the individual official for their conduct in denying you that permit? Now, of course, domestic law, the domestic law of the state concerned, might impose criminal responsibility of the official in certain respects. But insofar as it's an official act, it is at the international level the state that is responsible. And immunity is essentially there to prevent another state from holding the individual responsible, being able to direct the individual in relation to it. So that's the first purpose. Second purpose for immunity ratione materiae is, I think, purely procedural. So it's about this question of whether or not the legality of acts of a foreign state, whether they should be resolved by domestic courts of other states. So whether or not the state should, through its domestic law and through its domestic adjudicatory processes, be able to determine questions relating to the legality of the other state. So I think these are the purposes of the immunity of state officials, which go back, broadly speaking, to questions of sovereign equality, but don't align exactly with the immunity of state officials, with the immunity of the state itself. So broadly speaking, to questions of sovereign equality, but they're not exactly coterminous with state immunity. Now, the one question that I want to deal with today is the question of whether there are limitations to immunity ratione materiae outside of the context of international crime. So we'll deal with international crimes tomorrow. But are there limitations, or are there cases where a state official might act in the exercise of their official capacity but still be subject to the criminal responsibility of the state? So the first issue that might arise is whether or not immunity ratione materiae applies to all state officials or only certain types of state officials. And in this respect, in the International Law Commission, there was an interesting debate on last year when we were considering who was entitled to immunity ratione materiae, with some members taking the view that it only applies to those state officials who represent the state, not to all state officials. So there were some members of the commission who took the view that, well, in some states, academics, professors in public universities are state officials, but that they are not entitled to immunity ratione materiae, even in relation to things that they do as professors. And so, in their view, immunity ratione materiae does not apply to all those who act in an official capacity. The ILC did not, in fact, incorporate that as a limitation or an exception to immunity. But I guess the question is whether or the question is really, what does acting in an official capacity mean? And so whether acting in an official capacity means everything that one does in relation to the job, or whether or not international law itself has some conception of what acting in an official capacity means. The second question that has arisen is whether there is an exception for crimes committed by state officials on the territory of the forum state. And in particular, where the person, the state official who had committed the crime, is in the territory of the forum state without the consent of that forum state. And in particular, in cases where the activity is not consented by it. So the question is whether or not there is something that is akin to the territorial court exception that we see with regard to the jurisdictional immunity of states. Again, in the ILC's draft articles, this exception is not included. Having said that, in the commentary to the ILC's article as adopted on first reading, there's a paragraph that indicated that though this exception is not listed in the exceptions to international crimes, that international law does not, in fact, recognize an exception for crimes that are committed on the territory of the forum state. And in that commentary, adopted on first reading, the ILC referred to espionage, it referred to murder, it referred to kidnapping committed within the state, within the forum state. Now, there's some support for this exception in international law or this limitation. A famous case in this regard is the Rainbow Warrior incident. So in Rainbow Warrior, French officials blew up the Rainbow Warrior, which was a vessel of Greenpeace, which was in New Zealand. It was in Auckland Harbour at the time. New Zealand insisted that it was entitled to prosecute these individuals. And through the, shall we say, good offices of the UN Secretary General, some arrangement was reached whereby these individuals were to be detained on an island somewhere. In fact, they were sent to France, the French island, I should say, on a French island. But they didn't, in the end, actually, shall we say, serve their time on their French island. They were sent back to France rather early. It seems to me, though, that Rainbow Warrior is a case that it cuts both ways. Because, of course, New Zealand insisted that it was entitled to prosecute these officials, but France invoked the immunity of these officials. So, it's practice that goes in different directions. There have, in fact, though, been cases in domestic courts that have held that there is this immunity. So in a case in the UK courts, a case called Kurzpatz, a Mongolian official who had engaged in acts in Germany and who was sought for prosecution for these crimes in Germany was in the UK. Germany sought the extradition of this person, and the courts in this country held that he could be extradited to Germany on the basis that he was not entitled to immunity in Germany, even though he was a state official, even though Mongolia actually did assert his immunity and asserted that he was acting in an official capacity. The court held that he was not entitled to immunity because he was to be prosecuted in the state where the act occurred. More recently, there's been a decision of the German Supreme Court dealing with the blowing up of the Nord Stream pipeline. And there again, the German Supreme Court has taken the view that there's an exception to immunity with regard to this crime in this particular case, because in its view, the effect of the crime was felt in Germany. So one question that arises with regard to this, this possible limitation is, what does it mean to speak about crimes committed in the territory? So are we speaking about crimes that are committed by persons within the territory of the foreign state, or are we speaking about crimes that are committed in the territory in the sense that we normally understand in criminal law and in fact in international law? So do we, for example, include crimes that are initiated outside the territory but are completed within the territory, like the Nord Stream case? Or even if you take the example of the prosecution of Nicolas Maduro, that is in relation to drug trafficking, and the indictment is that whilst he was in Venezuela, he was in fact overseeing conduct relating to drug trafficking in. So that's one question that arises there. It seems to me that these questions about whether or not there's an exception to for the prosecution of crimes committed in the territory, the assertion that even if the person is not present within the full exception applies, these are relatively new assertions of this practice. I'm not convinced that actually, in general terms, there is an established practice relating to crimes committed by persons on the territory without the consent. But even if such an exception existed, to extend it, I think, to cases where the person is not present on the territory, but the crime is felt there, would be quite a significant extension. One argument, I suppose, in favor of this argument, one argument in favor of the position that there is a territorial crimes exception is to go back to the Schooner Exchange decision of the US Supreme Court. If you recall, in Schooner Exchange, the US Supreme Court was dealing with the immunity of the head of state, and the court argued that the immunity was based essentially on the basis that if a foreign head of state comes within the territory, that it is implicit in giving permission for them to come, and in that instance that they would be entitled to immunity. And so if you take the reverse, the argument would be that if you are not present, if you are present, but without consent, and certainly without consent to that activity, that then that implicit license does not exist. One last point, looking at the time, in relation to these crimes committed within the territory, espionage. So espionage, I think, raises different considerations, because with regard to espionage, by definition, the state is seeking to prosecute somebody for an act which is done on behalf of a foreign state. That's the assertion with regard to espionage. Now, to the extent that immunity ratione materiae applies to official acts done on behalf of the state, and to the extent that it applies beyond state officials, in other words, to agents of the foreign state that are not actually employed by the foreign state, then one would have thought that espionage by definition would fall within immunity ratione materiae, because it's an act that is by definition done on behalf of foreign states. Routinely seek to prosecute for this, and states generally do not invoke immunity. Now, that's not to say that they accept that the individual is an official, though actually in some cases they do accept that the individual is acting on the basis, but in general terms, states do not rely on immunity ratione materiae. Raises the question as to whether or not there is, in fact, an espionage exception, whether there's something different in relation to espionage on the basis of the lack of invocation of, on the basis of age, the practice in actually prosecuting, and the lack of invocation of immunity. So even if there is no general territorial crime, I think there might be a good basis for saying that there is at least an espionage exception. Okay, so what I have tried to do today is to sort of speak about immunity of state officials generally, to think about the reasons why international law affords immunity to state officials as a general matter. And then tomorrow, I want to focus on prosecutions for international crimes and to see whether the position is different in relation to prosecutions for international crimes in domestic courts. It's bang on 2 o'clock. So
Thank you very much, Lapo, for that characteristically thoughtful presentation. And you've set up the issue so well for tomorrow and Wednesday. Look forward to hearing what you have to say. So I invite you all to join us tomorrow at 1 p.m. for the second Dapo lecture.